Hello and welcome to this Brick Court Chambers podcast. I'm Tony Singla and today I'm joined by Tim KC to speak about banking and finance disputes. We're going to discuss some important judgments from the last year or so and consider how they may have an impact on banking and finance claims in the future. We will also talk about other developments in topical areas such as cryptocurrency and sanctions. Tim is one of the leading silks at the commercial bar and is recommended in the legal directories as a star advocate for banking and finance disputes in particular. He has acted in a number of high-profile disputes over many years and is a former winner of the Chambers & Partners Award for Banking and Finance Silk of the Year. Tim, thank you very much for speaking to me today. I'd like to start by asking you about one of the major banking and finance cases of 2025, namely the Supreme Court's judgment in the car finance case of Hopcroft and Close Brothers. That was a case which involved a number of members of Brick Court and was widely reported in the press. What were the issues and why was the case of such significance?
Thank you, Tony. The facts in very brief outline. These were three linked appeals which concern the payment of commission by finance lenders to motor dealers in connection with the provision of finance for the hire purchase of cars, where that commission was either not disclosed or only partly disclosed to the hirers of the cars. In a typical transaction of this kind, a person visits a dealer, chooses a car and agrees a price with a dealer. The dealer obtains an offer of finance from a finance company on hire purchase terms. This is then presented to the customer by the dealer, acting for that purpose on behalf of the lender. In each case under appeal, the dealer made a profit on the sale of the car, but crucially also received a commission from the lender for introducing the business to it. There was either no disclosure to the customer of the existence of the commission or partial disclosure to the effect that a commission of unspecified amount might be paid. Each of the customers brought proceedings against the lenders, claiming that the commissions amounted to bribes or to secret profits received by the dealers as fiduciaries. And the Supreme Court in this important judgment made a number of key findings. First, they held that because of the commercial context in which these various relationships arose, there was no fiduciary duty in this case upon the motor dealer. The potentially conflicting interests arising from their different commercial interests meant that such a fiduciary duty had not been assumed and was held not to have arisen. Secondly, they confirmed that the tort of bribery at common law, but went on to make clear that such tort would only be committed where there was a secret payment to a fiduciary. The banks had argued that such a tort should be entirely abolished, leaving people to their equitable remedies, but the Supreme Court disagreed with that. But the Supreme Court went on to hold that a purely contractual duty to give what was known as disinterested advice would not be sufficient to found that tort, in effect overturning the Court of Appeal decision in Wood and Commercial First Business. The Supreme Court in effect went on to do away with the distinct category of half-secret commissions by rejecting the Court of Appeal's judgment in Herstanger and Wilson, which had found that where the possibility of a commission has been disclosed, this was sufficient disclosure to negate the common law tort of bribery, but did not suffice as fully informed consent so as to exclude equitable remedies. The Supreme Court in Hopcroft held that the requirement for disclosure was the same for both the common law tort of bribery as well as the various conventional equitable remedies, and that fully informed disclosure was required. There is, as a result, therefore, no separate category of partially dishonest or half-secret commissions.
Thanks, Tim. So that was obviously an excellent result for the lenders overall, but the Supreme Court did hold the lenders liable in one respect, didn't they?
Yes, Tony. The borrowers made statutory claims under the Consumer Credit Act, and the Supreme Court held that in the case of one of the appellants, Mr. Johnson, and his lender, that relationship was unfair under Section 140A of the Consumer Credit Act, such that the commissions and the interest incurred thereon should be paid back by the lender to Mr. Johnson. So in the result, there will be statutory liability, potentially, for a large number of these motor finance claimants. The FCA then, in the light of that judgment, published a draft redress scheme and sought initial comments by last December. I was instructed by a client to assist with that process. The final FCA scheme is still awaited, but there could be quite a bit of litigation if claimants don't like that final scheme, because they will be able to opt out and retain their legal rights.
Now, moving on to a different topic, one of the major areas of developing law in banking and finance concerns the huge growth of cryptocurrencies and digital assets. Can you explain what's happening in this area, Tim? What should we be aware of?
Thanks, Tony. The rapid surge in these assets has in truth moved more quickly than the law, perhaps unsurprisingly, and disputes are fast emerging where conventional jurisprudence does not clearly cover the issues or map out the various rights and remedies. The fundamental starting point here is whether crypto assets count as personal property, since this is obviously a necessary quality for underpinning legal claims in relation to such assets, and there have been important recent developments in this area. English law has traditionally followed the dictum of Lord Justice Fry in the well-known 19th century case of Colonial Bank and Winnie, where he held that all personal things are either in possession or in action. In other words, to count as personal property, an asset has to be either a shows in possession, for example gold or coins, or a shows in action, for example a debt or shares in a company. Crypto assets did not fit neatly into such classification. But with commendable commerciality and adaptability, the common law has ridden to the rescue and sought to address these matters. It's been aided by the deliberations of other bodies, most notably the UK Jurisdictional Task Force, which was set up by the Ministry of Justice, and the Law Commission, which have each published statements and papers on crypto assets. In the case of AA and Persons Unknown in 2019, Mr. Justice Bryan recognised that cryptocurrencies, like Bitcoin, did not fit the traditional categories of either shows in possession, since they are virtual not tangible, or shows in action, since they did not embody a right capable of being enforced. The learned judge nonetheless went on to hold that it would be fallacious to proceed on the basis that the English law of property recognises only those two traditional types of property. He drew upon the UK Jurisdictional Task Force statement on crypto assets, and he further noted that cryptocurrencies did satisfy the criteria for property set out by Lord Wilberforce in the National Provincial Bank in Ainsworth because these assets were, number one, definable, secondly, identifiable by third parties, thirdly, capable of assumption by third parties, and fourthly, had some degree of permanence. Mr. Justice Bryan's judgment that cryptocurrency could be treated as property was expressly endorsed by the Court of Appeal in 2023 in the case of Tulip and Bitcoin Association, where it held that a crypto asset, such as Bitcoin, is property. This is all a rather long-winded build-up to an important recent development in this area, the enactment of the Law Commission's recommendation that legislation should confirm the existence of a third category of personal property beyond shows in possession and shows in action. Hence, the Property, Digital Assets, etc. Act 2025, which received royal assent on the 2nd of December last year.
So this is a very recent piece of legislation, and it's surprisingly short, isn't it?
Yes, Tony. Unlike a lot of modern statutes, it is a mercifully concise and clear statute. It really only comprises one important section, Section 1, entitled Objects of Personal Property Rights, and it reads as follows: a thing, including a thing that is digital or electronic in nature, is not prevented from being the object of personal property rights merely because it is neither A, a thing in possession, nor B, a thing in action. So there you have Parliament expressly giving the green light to the development by common law judges of the law as it pertains to the property rights arising in relation to digital assets. There will therefore, I think, be significant potential for disputes as to what the law should now be in relation to those assets, including the way in which conventional analysis and traditional remedies will apply to this new world. It may also be worth noting by way of a postscript that the government has laid further secondary legislation, the Financial Services and Markets Act, Crypto Assets Regulations, 2025, to create a regulatory framework governed by the FCA, which will come into force from 2027 for companies in the UK, as well as those overseas with customers in Britain. But by way of further development, in a recent criminal case in January this year, case of the Crown against Lakeman, the Court of Appeal held that gold pieces in an online computer game constituted property for the purposes of Section 4 of the Theft Act 1968. So there will be, in my view, an enormous amount of law developed by the courts in pretty short order in relation to digital assets and their protection in the coming years.
Now I'd like to turn to a different topic, that of sanctions. This is very much a live issue, especially so far as Russian entities are concerned. Are there any particular cases you would highlight, Tim?
Yes, Tony, there was an important Court of Appeal judgment back in 2024 on the topic, Celestial Aviation Services and UniCredit Bank. In that case, the defendant bank contended that it was unable to make payment under letters of credit issued by a Russian bank because of the effect of UK and US sanctions. The Court of Appeal considered the application of Russian sanctions regulations SAMLA, which is the Sanctions and Anti-Money Laundering Act 2018, Section 44, and the issue of illegality in the performance of an English law contract under the principle in Raleigh Brothers. The Court of Appeal held that the Russian sanctions applied so that payment could not be made. Obiter, it found that the bank would not have had a reasonable belief defence under Section 44.2 of SAMLA, and further, the Court of Appeal held that Raleigh Brothers' illegality would not avail the bank, as it had not made reasonable efforts to obtain a licence from the US authorities. And an appeal from the Court of Appeal was heard by the Supreme Court in December last year, and judgment is awaited. So it's very likely that there will be an important Supreme Court ruling on sanctions as they impact banking and commercial contracts in the course of 2026.
And finally, Tim, towards the end of last year, the Privy Council handed down judgment in Credit Suisse and Ivanishvili, which is a really important case for commercial lawyers and banking and finance practitioners in particular to be aware of. Can you tell us a bit about that case and why it's potentially so important?
Yes, Tony. It was genuinely a potentially hugely significant judgment of the Privy Council, where they considered, amongst a number of points on appeal, the test for reliance under English law in a claim for misrepresentation, including, importantly, fraudulent misrepresentation. This was an appeal from the Bermudan Court of Appeal to the Privy Council, and Lord Leggett gave the judgment of the board. I'll take this fairly shortly, as I and some other colleagues at Brick Court have done a podcast specifically on this case due to its importance, where you will find a much more detailed analysis. But the particular point of interest is really whether the claimant has to show conscious awareness of the misrepresentation in order to prove reliance, i.e. that they were thereby deceived. The Privy Council looked at the jurisprudence in the area, going back over the years, and in particular at first instance cases where it had been held that conscious contemporaneous awareness of the representation was required. Such cases included the case of Raiffeisen and RBS, and more recently, the decisions in Marmay, Leeds and Loreley. These were cases where the claim was based upon implied representations, and the first instance judges had all held that an assumption by the claimant did not count as reliance. The Privy Council also considered that run of cases where a claim in fraud had succeeded based upon an implied representation, and the claimant had not shown a conscious awareness of the deceit, as opposed to assuming that matters were otherwise than impliedly and dishonestly misrepresented. The Privy Council had, albeit obiter, no hesitation in preferring that latter line of authority, holding that there is no requirement under English law that the claimant was aware of the representation and understood it to have been made. As the Council argued unsuccessfully for the approach now endorsed by the Privy Council, in cases such as PAG and RBS, Leeds and Loreley, I trust I might be forgiven a wry smile of professional satisfaction. What is clear, though, is that this judgment is likely to have a very significant impact upon the prospects of claims by investors and borrowers against banks and other financial institutions based upon allegedly dishonest implied misrepresentations as to the financial products sold to them. In a number of cases, the courts have upheld implied terms that go to the integrity of the transaction, but the case is founded on the perceived need for the claimant to show conscious or active awareness of the deceit. These claims will now fall to be assessed differently in the light of the Privy Council ruling. The well-known helpful test, as it's called, taken from Geest and Fifes, it is now going to echo the way in which reliance is to be tested. That helpful test was put by Mr. Justice Coleman in this way: a representation can be implied if a reasonable person would naturally assume that the true state of the facts did not exist, and that, if they did, he would necessarily have been informed of it. The Privy Council and Credit Suisse have now aligned the test for reliance more closely with that test for implying a representation. This seems, at least to me, to represent a move towards making this area of law more coherent. That said, I can well imagine there will be cases which test this new approach entering the English courts in the coming years.
Thanks, Tim. So that seems like a potentially radical judgment for the law of misrepresentation. Does this development in relation to implied misrepresentations mean that the common law is moving towards imposing a positive duty of disclosure?
That, Tony, is a very interesting point. I think it depends a bit on your perspective and where you think the commercial law and the English law of contract should draw the line in terms of honesty and dishonesty in commercial dealings. And it's probably worth reminding ourselves of the famous dictum from Lord Justice Steyn about upholding the reasonable expectations of honest people. And he said this in First Energy and HIB: in 1993. He said this: "A theme that runs through our law of contract is that the reasonable expectations of honest men must be protected. It is not a rule or a principle of law. It is the objective which has been and still is the principal moulding force of our law of contract." And the reason I think that that's relevant to answering your question is that as commercial dealings become more sophisticated and complicated, the scope for trickery and deception seems to me to increase. And whereas a long time ago, when commerce was more simple, the caveat emptor perhaps worked perfectly satisfactorily, where you could see the product or the good in question and form your own view, with very, very complicated transactions and products, I think it becomes much more difficult for the party, very often the buyer, who doesn't have all the same information and understanding, to understand what they're actually getting into. The English law of representation still requires there to be a representation. So we are not at a point where there is any kind of general duty of good faith or some duty of disclosure in general commercial dealings. So you still need the representor to do or say something from which an implied representation falls to be inferred. But, true enough, this may include putting forward a transaction with a particular benchmark, as was found to be the case by the Court of Appeal in PAG and RBS, so as to derive an implied representation in relation to that, in that case, libel. So I think it could probably be said that Lord Legate's reformulation of the test for reliance serves to reinforce the importance of honesty in commercial and financial bargains struck under English law, and to advance the objective articulated by Lord Justice Steyn. As always, Tony, there are bound to be different points of view and cases which consider the ramifications.
Thanks, Tim. That seems like a good place to finish. Thank you very much indeed for a very insightful and topical update on banking and financial litigation.